Welcome to section 44, where we're going to kick things off by talking about the liquidation of entries, getting towards the tail end of the entry process. And for people unfamiliar with what liquidation is, that entry process, the finalization of the entry process, is a little bit longer than people might think. One thing that we haven't been too emphatic about, we've certainly mentioned it, but we do want to be really emphatic about it now, is in the first bullet. When an importer/filer, customs broker, submits an entry to CBP, what they are really doing is presenting an estimate of the duties owed to the U.S. government. When we file a 7501, we're not telling the U.S. government that these are the duties. We are estimating that these are the duties, because the government could come back and say, oh, wrong classification. Country of origin doesn't look right. Entered value is incorrect. The submission of a 7501 with the duties on it is an estimate. That's really important to understanding what liquidation really means. Second bullet, CBP can accept that estimate and release goods, but the process isn't finalized until Customs engages in what is called liquidation. And as we see in our last bullet, liquidation is the final assessment of monies owed to the government by CBP, where CBP comes back over a period of time, which we'll define in just a moment, and says, okay, that original estimate is good, the entry is liquidated, or Customs can say, you owe us more money. That's really what liquidation comes down to. In terms of time, CBP has up to 314 days from the date of an import to liquidate an entry. Second bullet, during that time, Customs can decide to assess a higher amount of duties owed or a lower amount. And as one might imagine, the instances of being informed of a higher amount are greater than an instance of being notified of a lower amount. In the case of CBP coming back and saying more duties are owed, a supplemental duty bill is sent to the importer. CBP has 314 days to do that. They actually have longer. We'll talk about that in just a second, too. Some of the reasons why CBP changes a duty assessment may include the incorrect HTS US code was used at time of entry, and the correct code has a higher rate of duty than the originally submitted incorrect code. Second sub-bullet, an incorrect dutiable value, that the entered value was incorrect, was too low when the entry summary was filed. Third sub-bullet, there could be a ruling out there that applies to a given entry that would compel Customs to state that more duties are owed, or there could be court decisions made on a similar commodity that applies to a product that an importer brought in. As we can see, there are multiple reasons why CBP can come back during the liquidation period and say, hey, there are more monies owed. Under normal conditions, entries will liquidate automatically based on the estimated duties presented in the original entry summary. That's to say that Customs accepts the original estimate presented on the entry summary in terms of duties owed, and the entry liquidates. It's over. The file is closed. However, as part of the liquidation process, that 314 days that Customs has to liquidate, CBP can extend its time for up to 1 year, and can do so a maximum of 3 times. That's important to know. As a trade tip, the entire liquidation process, once again, is now managed through ACE. To learn more about the liquidation of entries, all of that is found in 19 CFR Part 159. Needless to say, we can recognize this screenshot. It's ECFR. Title 19 goes straight to Part 159, the liquidation of entries. If we have questions about anything to do with the liquidation of entries, this is where we find the answers. Subpart A, general provisions. We can get a definition of liquidation. We can learn about minutia, like the rounding of fractions. Liquidation for the importation of alcoholic beverages. And moving further down, Entries liquidated by operation of law, that's the 314 days go by. There's no extension taken by customs. That's it. End of story. And any extensions of time for liquidation. Just another example of the specific resources out there, in this instance through ECFR, on the topic of liquidation. The second part of this section deals with what's referred to as filing a protest, where we as the importer disagree with a decision or ruling passed by customs, and we have the opportunity to protest that decision. Let's see how that works. A protest is the formal method through which an importer can dispute a decision made by CBP. The following scenarios are subject to a protest. In other words, situations where an importer can present a protest. In general terms, first sub-bullet, clerical errors, mistakes of fact, and other inadvertences. That's just some fancy terminology for customs made a mistake, and we are protesting that honest mistake, and we're looking for a decision on that protest. There are also administrative decisions that can be protested. The appraised value on an import, where, for example, we as an importer stated an entered value of $100,000, and customs came back for whatever reason and said, oh no, it's $120,000, which would increase our duty exposure. That can be protested. Customs states that a certain import is under a different classification than the one we use. We can protest that as well. Protests are allowed on rates of duty. Needless to say, we as an importer don't want to find ourselves in a position to file a protest because it's really questioning a decision that the U.S. government made. But we certainly have the right to do that and the means through which we can do that. And that is filing a protest. As we like to be thorough, we're putting up a screenshot not of ECFR, but the actual excerpt from 19 CFR Part 174 in PDF format, which deals, of course, with protests. Subpart A, general provisions. Everything starts out with definitions, a good place to begin. The applicability of these general provisions, and power of attorney to file a protest. That actually deals with using a customs broker to file a protest on behalf of an importer, and the fact that a POA has to be in place to do that. Subpart B, matters subject to protest. We just talked about that in our previous slide. The situations under which a protest can be filed. We can learn specifically what those scenarios are by going to 174.11. The filing of protests, the contents of the protest itself, any amendments after the fact, on and on and on. Subpart C, conversely, on the right-hand side, provides details on the review and disposition of protests. How much time does customs have to review a protest? A process known as accelerated disposition of a protest, further review. What is the criteria for further review? Moving down the list, allowance of the protest or denial. That's found in 174.29. Notification of a denial and publication of that denial. We're just being specific about where information can be found, about what protests are, what topics can be subject to a protest, and how to find specific information about filing protests. All right, we're really coming down to the wire now because we're done with this section. We talked about liquidation and protests. Now we're going to sprint to the finish line with 3 more sections, all of which deal with best practices for working with customs brokers. Let's finish up strong. And to do that, you need to come back quickly.